Hi friends, in this video we are going to deal with the case summary of the important and latest Supreme Court judgment pronounced now in the area of service law, that too in relation to selection process matters. To know more about it, please watch the video fully. If you feel that it is useful to you, please like, share and comment, and don't ever forget to subscribe to it, and further click on the bell icon next to the subscribe button.
Hi everyone, in this video I'll be discussing about a latest Supreme Court judgment. In the important judgment titled Krishna Rai through legal representative and others versus Banaras Hindu University through registrar and others, which was pronounced on 16th June 2022, the Honorable Supreme Court has held that the principle of estoppel or acquiescence will not apply in the selection process when it is held contrary to the relevant rules. The facts of the case would be that for filling up 14 posts of class 3 junior clerk grade by way of promotion, the university issued a notification or an advertisement inviting applications from permanent class 4 employees for promotion as a junior clerk. After the interview, merit list was prepared by the Board of Examiners appointed for making the selection or promotion, and accordingly, as per its recommendation, 14 selected candidates were issued appointment letters. So, the appellants made a representation against the decision to appoint those candidates, which was rejected by the competent authority. Being aggrieved, the appellants filed a writ petition. The single bench set aside the selection process by holding that Board of Examiners committed grave error in making selections by awarding marks on the type test, written test and interview, and then preparing the merit list. So on appeal, the division bench set aside the judgment of the single bench on the ground that after having participated in the interview without protest, the applicants are stopped from challenging the selection process after becoming unsuccessful. Challenging the division bench verdict, the appellants have approached the Honorable Supreme Court. The Honorable Supreme Court has held that as per para 6.4 of the manual duly approved by the Executive Council's resolution, all class 4 employees who have put in 5 years service and who have passed matriculation examination or equivalent would be eligible for promotion to the post of junior clerk grade. The only test required for eligible candidates was to pass in the departmental test, that is, the test of simple English, Hindi and arithmetic. Thus, if an eligible candidate passes in the written test of simple English, Hindi and arithmetic, and he also passes the type test, he would be entitled to be placed in the seniority list for promotion. If further mandated that even where eligible candidates passed in the departmental written test of simple English, Hindi and arithmetic, but could not pass in the typing test, would still be eligible for promotion and be placed in the seniority list with the rider that he or she would have to qualify the typing test within 2 years, and such typing test for these promoted candidates would be held twice a year. That is to say that they would have at least 4 chances of appearing in the typing test and qualifying it subsequent to their promotion. In the present case, the Board of Examiners, comprising of large number of members, changed the entire procedure and they established a completely new procedure. They awarded 20 marks for the type test, treating it to be compulsory, 60 marks for the written departmental test of simple Hindi, English and arithmetic, with 20 marks for each subject, and further introduced an interview of 20. Thus, the merit list was to be prepared on the total 100 marks. There was neither any provision nor any other indication in the manual duly approved by the Executive Council for preparing such a merit list based upon the marks awarded under different heads. The promotion was to be made on the basis of seniority subject to passing the departmental written test. Once the candidate was eligible, having 5 years experience in class 4 and matriculation certificate or equivalent, the intention and object as called out from the aforesaid eligibility procedure was that seniority subject to qualifying the written test would be the criteria for promotion. The Board of Examiners on their own changed the criteria for promotion and made it purely merit based by introducing an interview and also preparing the merit list on the basis of marks awarded in the type test, written test, and interview. However, the division bench fell in error in applying the principle of estoppel that the appellants having appeared in the interview and being unsuccessful proceeded to change the same and on that ground alone allowed the appeals set aside the judgment of the single judge. The division bench having approved the reasoning of the single judge ought not to have interfered in the judgment of the single judge on the technical plea. The division bench ought to have considered that the appellants were class 4 employees working from the 1977 onwards and expecting from them to have raised serious objection or protest at the stage of interview and understanding the principle of changing the rules of the game was too far-fetched, unreasonable and unwarranted. It is settled principle that principle of estoppel cannot override the law. The manual duly approved by the Executive Council will prevail over any such principle of estoppel or acquiescence. Therefore, the impugned judgment of the division bench is set aside and the judgment of the single judge bench is restored. Since the examinations have already been held in the year 2006 to 7, and all the appellants who are found to be eligible for promotion as per the existing rules and as directed by the single judge would be extended all consequential benefits. Further, where the appellants have died, the benefits would be extended to their legal heirs entitled under law for the same. So that's it for this video. Hope you'll find this helpful.